Ray Schutz was there, and Ray wasn't a necessarily very sophisticated estate planner, and I mean that from the standpoint of the size of the estates necessarily worked on. But he taught me some very good commonsensical things, a lot of which I'm sharing with you today. Wonderful man, honorable guy. If you delve into more sophisticated estate planning, then find someone who has set up a charitable remainder trust inside of a trust, or a Q-tip, or understands crummy powers, and all of those various things that you hear about, but you don't really get exposed to. The most helpful thing that you can do is talk to someone about a plan they've set up, and why did you do these things? Why did you make a grant or a trust? Why is it intentionally defective? Why are these various provisions in here? That'll be the simplest way for you to understand and get a grasp, that's a grab and something else come on. To grasp what the overall concept is and how the pieces all work together. You guys can call me. I know I say that with some kind of trepidation about getting 50 phone calls. Maybe if I screw this up enough, then nobody will want to call me anyway. But honestly, if you have a question, someone in your community that does estate planning work, I'm sure would be willing to answer a question for you. I would be willing to answer a question for you. I did not bring a bunch of forms today because I don't know what you want or don't want, but I will tell you that after we get done, if you want to see what I use for a sample, for a simple will, or a durable power of attorney, or a simple will with a trust provision for a family or something like that, I'll be glad to email that to you and share it with you. So my information's in the State Bar Directory under Aberdeen. By all means, shoot me an email and I'll send you something. Or if you have a topic you'd like to talk about, call me up and I will do my best to get your call returned timely. Because as all good attorneys, the notes I wrote today, I wrote in my car, in the fog, while shaving and eating a donut. But here I am, safe and sound. I didn't. That would be safe. Okay, so that's kind of my general overview. I don't know how far are we?
About 10:26, and you got until 10:50.
Oh, we got 24 minutes. How about we talk about some of the documents? Wills. There is this thing called the code. Wills are codified in 29A-2, chapter 29A-2. Multitude of information in there. There's some basic things to keep track of. Competency. Always make sure, obviously sometimes, can't say obviously, it's obvious. Many times it's obvious that your client is competent. If there's any question whatsoever, you need to do the competency test. The Supreme Court has a litany of cases. I'm not really sure how to pronounce Podgorski, I believe, is the one from '78 that kind of set out the test the Supreme Court looked at. There was a case a couple of years, about 5 years ago, called Doken, I think is how they pronounce it, kind of the West River, that went through. And then a State of Berg is another recent case. I'll give you, if anybody wants it, I'll give you the site for Podgorski. It's 271 Northwest 2nd 52. You're all smart and can shepherdize that and find out all the cases afterwards. But that was the Supreme Court's proclamation of competency. And I encourage you to read the cases, Podgorski and Doken and Berg, because they set out a lot of factors to look at and consider for competency. Competency can come and go. It can be fleeting. If a person is lucid at the time they come into your office and make these wishes known, and it's for what the Supreme Court deems a reasonable length of time, then it doesn't matter if the person was, bat crap crazy before and they are, down the road. If during this time they were lucid when they made the documents and they signed them, then that's what's important. Did you have a question?
Yeah, quickly. Do you ever do video wills?
I've never done one, but I know people that do video wills, and I think it's a great tool. What I do is I try and have a witness in the room. If I'm going to do a competency test, recently, about a year ago, I had a person in the hospital, and we needed to get some planning done. So I brought an assistant with me. I ran through the competency determination. I actually had the witness do an affidavit, stuck it in the file. So far nothing's happened, but if there's going to be a challenge to this, you know what's going to happen. Is they're going to challenge competency or one of the other factors. But I think a videotape tool would be excellent. get video evidence of what's going on, the questions that you asked, all of that. It's probably something a younger person would do because I'm so old that I don't think about those things. But yeah, it's a great idea. Participants. Oftentimes, particularly older people will show up and they'll have a son or a daughter or a niece or a nephew. Had one this week. Lady showed up, lovely little lady, 75 years old, and she showed up with her niece and her nephew. I said, hey, how are you? Nice to meet you. Can you go stand outside for a while? And so I sit down and I talk with you. I said, okay, who brought you here today? Oh, that's great. Why are they here? Okay, have they talked to you about your estate plan? Have they indicated how you should do your estate plan? Walk through the questions and find out if there's some undue influence going on. Usually there's not, I will tell you. Usually it's, well, they help me, I trust them, and if that's the case, then so be it. Note in the file that they're there and they're going to be engaged, but then check back with your client at every meeting and make sure if they show up that it's still okay. And that there's been no undue influence that's occurred since then. And then I always make it an interactive process. When I sit down with the client, I give them a pad and a pen, and I say, we're going to talk about a lot of things today, and you're going to have a lot of homework when we get done, because I'll guarantee you haven't brought your all the names, address, social security numbers of your kids. Maybe they have. Your last deeds of record, your legal description of your house, all the accounts and the balances and numbers. So I make it interactive. I want them to be involved in this. I don't want them, most of the time they just want to go, okay, well tell me what I need, and give me that documents and tell me where to sign, and then I'll go away. I don't let them do that. I make them be as involved as I possibly can make them be involved in their estate plan. And to do that, I make them bring me things, and I make them understand why this is important. Basic real requirements, you learned it all in law school. You've got to be competent. 18 years old is one of the competency requirements. It's got to be in writing, it's got to be signed, witnessed by 2 more people. Obviously, we can do a holographic will, which is all handwritten. I've never had one. So maybe you all have, and if they do, then why would they need us? Domicile has been an issue in several of my wills. Where they make their permanent residence is going to determine what the situs of their will. And so there's a variety of factors that go into it. It can be driver's license, where they file their tax return, the address they list on the return. What you'll oftentimes see is I have a lake home, and I have a town home, or I have an Arizona home, and I have a summer home. And well, I send 6 bunches. Pick which one's the one going to be, because we've got or if it's not pick, it's, okay, well, I'll tell you which one it is based on these factors that go into determining which one is the correct domicile for purposes of your will. And that'll then come into play for probate, too, where we're going to probate your estate. Obviously, a variety of property is not controlled by the will. Joint tenancy, which is another form of just transfer on death. So any TOD, which would be like life estate, real estate, any payable on death, life insurance, some broker accounts for TODs. So a lot of, and so again, it's educating the client to understand that, well, okay, well, I've got, what am I going to do this in the probate? I said, well, it's not part of your probate. It says, on here, you already deeded this land to your son and reserved a life estate for yourself. So at your death, all we're going to do is file an affidavit returning the joint tenancy and a copy of the death certificate, and that transfer is absolutely complete. Same thing with life insurance. Same thing with a lot of things. You may have to have a probate to get a PR to send the paperwork to life insurance, but it doesn't. If the will is not going to change the beneficiary if the life insurance policy is already in place. Even my simple wills, actually probably especially my simple wills, I will, again, the young family scenario. We have various partners. We have obviously the first representative, but there's also maybe a guardian and a conservator, and it can all 3 be the same person. We know that, but what I like to sit down and explain to them is, you may have a sister or a brother who's just phenomenal with raising kids. They've got 4 of their own, and the kids all get along together, but they can't balance a checkbook to save their life, and all of a sudden you're leaving them $1 million of life insurance and a variety of other things. It's okay to separate the conservatorship duties from the guardianship duties and just make sure they can work together, and the guardian can petition the conservator for funds and get on a stipend, and you can specify all this out. So I let them know that it's okay to separate those duties out, but it's also okay to keep them all together too. How are we doing?
About 15 minutes.
Awesome. Will contests are going to come from improper execution. We talked about that. Make sure that you've got witnesses. I always make sure those signatures are notarized. Mental capacity, we talked about testing for that. Duress, again, through your intake process, through your inquiry, that should be part of your questioning is, are you here under your own free will? Is somebody forcing you to do this? Undue influence, we talked about that a little bit. And then fraud. The other thing that I think is important that maybe a lot of practitioners overlook, especially as practices get really busy and it's a simple will, and just stop in, your will's already, you reviewed it, you said it's okay, I'll get to the front desk and my assistant will come down and you can sign it, show them a couple witnesses, and then she's a notary. Persh v. Jones, 397 Northwest 2nd. I don't have the page on here, sorry. Anyway, Persch, P-E-R-S-C-H, says, that's absolutely verboten. It states that the execution of will requires the use of legal knowledge and skill and the implementation of statutes so as to assure proper execution and attestation. So someone signing their will is the practice of law. A banker can't do it. An accountant can't do it. Your legal assistant or paralegal can't do it. Only a lawyer can be there for the execution of the will. The next big group of documents, I guess, are the powers of attorney. Powers of attorney, you all know what they are. They are a document in which you set forth and give certain agency authority to one or more individuals. They can be limited or general. They can become effective immediately, or they're springing upon my incapacity. We work oftentimes in estate planning with durable powers of attorney that are springing upon my incapacity. Then this person can act in this capacity for me, and that's where the limit or the general. It can be very broad-based, or it can be very narrowly tailored. My folks went on a trip overseas, and they gave me the power to pay their mortgage. It's very limited. They didn't trust me with much else. The interesting thing, or maybe not, is how power of attorney documentation has evolved, I think, since I started in private practice. When I came to the firm, there was a standard form everybody used. It was 2 pages. And essentially said, I give this person the power to do everything for all of my stuff, including my taxes, and blah, 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 and that was kind of it. And then the IRS came along and started implementing rules and said, you need to specify which tax matters they can handle on your behalf. So it's your personal income tax return, then you need to say it's a 1040. If it's a business return, then you better state that. If they're going to file your quarterly returns, then you need to say that. So be mindful as part of your intake what their tax requirements are, the reporting requirements, and then give that detail in your POA form. HIPAA, Health Insurance Portability and Accountability Act, has a specific reference in the release for the medical practitioners. I ran across this right after HIPAA was passed, where nobody would release information to my agent under the power I drafted, because we didn't specifically say including HIPAA material. So make sure you include a specific reference to HIPAA if you want them to have access to medical records, if your POA is going to serve as a medical POA as well, which, by the way, they can also be separate from financial and medical. You can essentially craft the POA any way you want to, and that's where the limited aspect comes into it. Most people I find out want to have, if there's a person they trust, they kind of trust them to do everything, but I think it's part of your job is to make sure that the person's competent to do everything. So just because they're a great person, are they the person to run your financial affairs and make sure your bills are paid in time, or are they just the right person to decide whether you should have surgery or not? I always insert in my power of attorney form a healthcare provision. If they don't want it, they want it separate. I recently drafted a separate healthcare power because they didn't want those things separate. But if you're going to include it, I make it very general, and I make it very flexible. So I include a three-step process. Number one is communicate with the person who is the power giver. So if they're in the hospital and they're in a bad car accident and you've got to make a healthcare decision, it's not end of life, it's not living will time, but there needs to be a procedure. The first step is communicate. Can you blink? Can you squeeze a hand? Can you do some way to communicate whether or not you want this procedure? If they can't communicate, then step two is then you, as the power holder, are supposed to recall any conversations you've had, which, by the way, as part of your explanation to the person you're drafting this document for, is share the document, share your wishes. Give it to the person you're empowering, give it to your healthcare provider, give it to your, meaning your doctor, also give it to the clinic or wherever you routinely treat, and then if you go to Arizona, take it with you and put it in your wallet or purse or whatever else so that it can be followed. If you don't communicate what's in there, it's not going to be followed. So, recall the conversation, have conversations with the person you've given this power to so that they know how you feel about certain things, procedures, particularly if there's any religious mandates involved. And then the final step is if I haven't communicated and you can't communicate, then act in, the general, act in my best interest. What would you know me, I've appointed you to this role, so what would I want done? Interestingly enough, STCL 59-7-2.2 allows the recording of a power of attorney, which does a couple things. Number one, a certified copy then, based on that recording, is the same as an original. But more importantly, if there are some land transactions that have to be done, your power is in the public record then. It becomes much easier to accommodate. You don't raise any claims on title and things like that by recording it. And by the way, the general power of attorney chapter is 59-6. I apologize. Next document is living will. South Dakota codified that in chapter 3412D. They conveniently enough provided a form for us. Here it is. It's I don't really like it. I kind of do my own. What that statute essentially does, it says if you want to have some say in whether artificial nutrition or hydration is used in an end-of-life situation, your living will allow you to have a say in that. But if you don't include that, then the law says it'll revert to whatever state law is governing that, which means probably the Hippocratic Oath is going to come into effect and the doctor's going to have to make the determination accordingly. So if you want to say in it, include the artificial nutrition and hydration. If you think about it, it's kind of a narrowly tailored form. You can, and that's why I use something different. I will include that, but I also make it much broader. I will allow them to make some statements about, near-death care and some things like that. And again, religion may dictate a lot of the choices that they make. I personally have not come across someone in which their religious beliefs prohibit certain medical care, but I know others that have, and it can be a big deal to be sensitive to. Okay, I'll take a deep breath. Any questions on what we covered so far? Yes, sir.
Regarding springing powers of attorney, springing documents
Yeah.
that go into effect upon disability,
Yep.
how do you draft a sort of statement in there that specifies what disability is when that document goes into effect?
Excellent question. Generally speaking, we'll make it based on either the treating physician's determination. Sometimes if they're going to be away, we will say it's the treating physician's determination along with maybe my local physician with a confer, because it's really easy to consult somebody long distance. So I will generally, unless the client objects, I will generally make it a medical determination. Anything else? Because the next topic is the one that we could really talk for, a month on, and that's trusts. And I bet we don't have a month, do we? What are we down to?
7 minutes.
All right, so I wrote down trusts that I have worked on, or trust provisions recently, and I've got 3 pages of just types of trusts and trust provisions that we've worked on. So this, unfortunately, does not lend itself to a very definite discussion, a very specific discussion. So let's just talk in trust generally. Trusts are, I view them as a contract between the person making the trust and the beneficiary and the trustee. I think trusts are wonderful tools, given the right purpose, the right reason for implementing them. What I don't think are the right purposes is when someone comes along and says, I will sell you this package and you can avoid probate, and it's only $2,000. And I say, well, I can do your entire probate for $500 because you don't have anything. I mean, it's what, and that's including opening and publishing and closing. So trusts are not a panacea, they're not an MLBL, they're a very effective tool, particularly for very sophisticated, very complicated estate planning, but also for some very smaller estates. Like I said, the example I've given earlier, the young couple with kids, they may want to give each other everything, but they go on the little 5-year anniversary trip to Vegas, and they both go down in the fiery plane crash. Who's taking care of the kids? Because if they don't state it, then we've got the families fighting everything else. So a trust provision in there, naming guardian and conservators is all critically important, even though they don't have any necessarily money either or assets to fight about. So trusts are very, like I said, a very useful tool, very important, but they have definite specific applications. Where's my trust section? Here it is. Okay, so Title 55. They gave a whole title to this baby, not just a chapter heading. So Title 55, there's many chapters within there. One of which is 1A, which is trustee powers, 40 of them, by the way. And what I find interesting is when I read a lot of trust documents, including the ones I used to draft initially, is I give my trustee all the powers enumerated in South Dakota 55A1-1. But what the law says is unless you exclude them, they're automatically included there. So you don't really have to include the provision of they have all these powers. It's only if you want to exclude some of these powers that you need to list them out. De facto, they're included. They have the power. Also, the Uniform Trust Act 55-4, Chapter 55-4 is a very important provision of the law governing trusts generally. Be very familiar with all of those sections. I encourage you to read through the code. It's amazing. Somebody told me this once when I was about, a couple years out, and they said, every once in a while you sit back and read the code. It's amazing what you find in there. It's kind of right. So let's just talk generally about trust as a whole, as what they can do. Trusts are very effective for asset protection and for estate tax avoidance. The current federal exemption for gift tax, thank God they unified, or estate tax is $5.43 million in 2015. That escalator clause will go up for 2016. We'll figure out what that is. Where I use trust a lot is when we, other than the small estate scenario we've already talked about, is when we get above $10 million in assets, when we need to start creating some mechanisms in place to either avoid federal estate tax or to, generally speaking, asset protection. So if you have blended families, second marriages, they also become very important. These are the areas where I'd strongly encourage you to get a mentor. It's a minefield, and if you screw up one of these, it's big money. So don't be afraid to ask questions. Don't be afraid to tell me or to tell anybody, ask anybody, why, if you have this trust, do you still include an AB provision in the trust? We had one of these just this week where we had done some gifting, crammed down some estates through a limited partnership and made a gift into a trust, and we had about $500,000 left over of the exemption. So we created an AB because, number one, we don't know what's going to happen with the law. And that's the other reason, by the way, to get people to do some estate planning is, what if the government decides we need more tax money, and we're going to take that $5.3 million and put it back down to where it was for years, which is $600,000 or $1 million. And now all of a sudden, which is an estate which is not subject to federal estate tax, all of a sudden becomes subject to federal estate tax. So we have a really good opportunity that we've never had in the history of this country. They adopted portability as well, so check the box, and now the couple has, surviving spouse has $10.86 million. Get them in, get them to do something. If they have that much wealth, there's techniques to cram it down, to make it smaller, to make a gift to in trust, and then let it grow in the trust. 2 minutes, got it. And I'd be happy to have a more thorough discussion, or at least a more thorough overview of that, because again, I still learn things about sophisticated estate planning techniques all the time, but be aware of them. The last thing I really want to touch on is, I guess, a topic that I deal a lot with, and that is business succession planning. I don't know what your practice areas are, but if you are like me, and you're going to end up starting as a general practitioner, and even if you're not, even if you're already somewhat specialized, you're going to probably have a client at some point in time that has a business, whether it's a farm, whether it's a Main Street business, whatever it is. And now we've got to talk about how do I get it to my kids without either a bunch of capital gain tax or torquing off the rest of the family or everything else. And oh, by the way, I can't just give it to my kid because I've got to have some money myself yet. I'm old, but I'm not dead. So business succession planning I find extremely rewarding. I've been fortunate enough to represent a lot of multi-generational family businesses in Aberdeen, in the Aberdeen area. And there's a lot of estate planning tools that come into play when you talk about succession planning. So they kind of are interwoven, they go hand in hand with each other, estate planning and succession planning. Lastly, experts. I always say that I'm the dumbest guy in the room, most of the time it's the truth. So I consult with numerous other experts, certified financial planners. If you have a client that has a portfolio of securities or bond holdings, I understand those. I was a finance major in undergrad, but I don't view that I want to either take on the risk or the responsibility of advising how to invest that, to provide an income stream, to support your estate plan, to support gifts you want to make to the kids because your son's going to get the farmland. So deal with a certified financial planner or some other investment advisor that